Ladies and gentlemen, you're watching Safer Arizona Wire. I'm your host, David Stephen Wisniewski.
And I'm your co-host, Tom Dean, attorney for cannabis.
Tonight, we're going to be talking about a phrase I've been seeing thrown around the internet, No Mens Rea. What is it? Is it a cure-all for every cannabis charge? Can it get your charges thrown out or dismissed? And how do you get your charges actually dismissed? All that and more up next, but first, a message from our sponsors. This edition of Safer Arizona Wire is sponsored by azmarijuana.com, Arizona's #1 marijuana industry website. azmarijuana.com is your top quality source of Arizona cannabis news and so much more. Bypass the online censors. Sign up for their email list so their content gets sent directly to your email. Bypass the social media shadow bans. Google search AZ Marijuana Facebook, like and follow their page so their content gets sent directly to your feed. Now, back to today's regularly scheduled broadcast. All right, and we're back. This is the Safer Arizona Wire, and a lot of you guys know me. I'm an activist for cannabis legalization. I've been doing it for quite a while. I've been a part of a lot of different ballot initiatives, and I like political action. I like when people go to the legislature and try to pitch different ideas to the lawmakers and try to get them to do stuff too, but I don't have a whole lot of faith in our lawmakers, and I like the ballot initiative process. But what I've been seeing out there is people saying, don't even bother with that. Don't even bother with trying to change the law. Just say, no mens rea. And I'm like, okay, well, what's this no mens rea? And I looked it up. And allegedly, it means without guilty mind. And I was like, okay, well, I want to talk to the experts. So I brought over here Tom Dean, attorney for cannabis, and we're going to cover what no mens rea is. Tom, break it down. What is no mens rea?
Well, let's talk about what mens rea is.
Okay.
Mens rea is, there's two components to any criminal offense. One is called actus reus, and the other is called mens rea. These are Latin phrases that we don't usually use anymore. They're kind of antiquated. We use regular English language anymore, but mens rea translates into guilty mind. Actus reus means that's the act itself. So let's use possession of marijuana as an illustration of how these two principles operate. So let's say that you put on your friend's jacket, and there's a marijuana. There's a bag of marijuana in the pocket of that jacket. The actus reus is that you physically are in possession of that marijuana. It's in the jacket that you're wearing. But that's not enough for a crime. They have to also prove that you had the mens rea, or the active mental element. In this case, with possession of marijuana, the mens rea is knowing. And we'll talk maybe a little bit more about those different mental states. So as long as the state can prove beyond a reasonable doubt that the person wearing their friend's jacket not only had marijuana in their pocket, actus reus, but also knew it was there, mens rea, then that's sufficient for the conviction. So the different mental states for mens rea in Arizona and pretty much every other state and federal, under the federal criminal code, is recklessness, where you're aware of a risk of a substantial risk of harm and consciously disregard that risk. Knowing, where you know that an object, or in the case of marijuana, you know that marijuana is in the pocket, but you act knowingly. In other words, that you know that the harm is going to occur. And then intentionally is the highest level of mens rea, and that means that you intended the harm. So recklessness means there's a risk of harm that you disregard. Knowing means that you know a harm's going to occur, but you act anyhow. Intentionally means that you intend to bring that harm about. That is your purpose or objective. For marijuana charges or any other drug charges, the requisite mental state is knowing. So that state has to prove that you knew that you had the marijuana in question. That's the mens rea. So let's just, and the mens rea applies to every element of a crime. So in marijuana, you're not just charged with knowing that you had this bag of green leafy substance in your pocket. You have to know that that's there. You also have to know that the green leafy substance is marijuana and not oregano, or maybe not hemp. Now, this is a defense you're going to start seeing more of now that we have hemp in Arizona. And I can tell you, I've already got clients who have said, this cop, he took my CBD vape pen. I told him it wasn't marijuana, it was hemp. Well, then, even if that person bought that vape pen, reasonably believing it to be hemp-derived CBD, but it later gets tested and it ends up having a higher level of THC, even though it technically isn't hemp, if he thought it was, if he reasonably believed it was, then he didn't knowingly possess marijuana. He thought it was, he was mistaken in thinking that it was hemp. That's a defense. So mens rea can really be a defense in these cases.
So we went over mens rea, but what does it mean, no mens rea?
Well, that means that you don't have, in other words, you didn't know in marijuana. The mens rea in a possession of marijuana case is that you didn't knowingly possess marijuana. So the no mens rea means I didn't know it was there, or I knew it was there, but I didn't know it was marijuana.
So in that case, is it really a cure-all for any and every cannabis charge?
Well, it's not a cure-all because it's always a question for the jury. It's a defense you raise at trial. So you go to trial, and if it's a misdemeanor possession of marijuana, it could be with a judge. Usually it is, not with a jury. For all other marijuana-related offenses, cultivation, sales, transportation, importation, those are all higher level felonies. They're always going to be with the jury. So what the state has to do is prove beyond a reasonable doubt that you knew. So if you're driving around, you got 100 pounds of marijuana, they find in your trunk, they have to prove that you knew it was there, or at least convince the jury that they believe that you knew it was there. Now, for example, I had a case to illustrate it with a guy had 400 pounds in his car. There was 2 other people in the car, both of which pled guilty and went to prison. My guy, we went to trial. I brought in one of the guys who already had pled guilty and went to prison, who testified that he had snuck the marijuana, put it in my client's trunk in the middle of the night because he knew that my client would never have let him do that. So he couldn't let him know about it. So my client didn't know the 400 pounds of marijuana was in his trunk because his friend had put it there. That was a not guilty verdict. Or
so that would count as mens rea in that case, or
that
no
was
mens rea.
Yeah, that was no mens rea.
So there is areas in law where, even in cannabis, where no mens rea is a defense, and so defense. that was the defense there. What other places, like you were talking about hemp earlier?
Yeah, look, for hemp, if you have what you believe to be hemp flower, that you reasonably believe was hemp flower, and you have it taken and you're charged with possession of marijuana, then or let's say you're a smoke shop that's selling what you believe to be hemp flower.
So I feel like the context, people are saying it in a little bit different context, that they actually are saying, I don't have a guilty mind because I don't feel guilty, not so much that I'm actually not guilty of the act.
Yeah, it's a very important distinction. Mens rea has nothing to do with whether you feel guilty. Like, if I were convicted of selling marijuana and sentenced to prison, I would never at any point, even going to prison, feel guilty because I wouldn't think I did anything wrong. I don't think there's anything morally wrong with possessing, using, or selling, growing marijuana. So I would never feel guilty, but that's not, the guilt has nothing to do with how you feel about the law that you're charged with violating. It has to do with the assigned mental state that the legislature assigns to that crime, whether it's recklessly, knowingly, intentionally. For example, reckless driving is a misdemeanor. That's a crime. They have to prove at least that you were reckless. If all they can prove is that you were negligent, that's not enough. Negligent is a lower mental state than recklessness. So they have to prove that you were aware of a substantial risk of harm and consciously disregarded it, not that you were just accidentally or unaware of that risk. So I know I don't want to get too technical, but it's nothing to do with whether you agree with the law or whether the law is moral or just or anything like that. It's just that again, in the case of marijuana, that you knew you had marijuana.
So if you end up bringing it up as a defense anyways, and the jury decides there was no guilty mind, there was no mens rea, doesn't that also sound a lot like jury nullification?
No, it's not jury nullification because that proving the mental state is an element of the crime.
So what's the distinction between that and jury nullification?
Jury nullification, is where the jury says, look, we believe that this person did break the law by possessing marijuana without a medical marijuana card. But under the circumstance, or he's a medical marijuana patient, let's say he was found to be in possession of 3 ounces. So it's over 2.5 ounces. But the jury may say, come on, this guy's allowed to possess 2.5 ounces. Okay, yeah, technically he broke the law and he's guilty, but we don't think that it's fair to apply the law in this case. And so we're going to say not guilty, even though technically he's guilty. That's called jury nullification. What are they nullifying? The law. They're nullifying the law that says that this person's guilty because they've decided that they don't believe that that would be fair in this particular case for whatever reason.
Well, can you think of any other cases or instances where you believe in cannabis that no mens rea is a legitimate defense?
So I've illustrated it with possession of marijuana. I illustrated it in a charge involving transportation of marijuana. Let's see, we could in sales of marijuana. I illustrated it in the area of the sale of marijuana, where a smoke shop believed that they were selling hemp. They purchased what they thought was hemp from, let's say, an Oregon hemp licensed grower, and thought they were selling hemp. Turns out to be marijuana, but they were mistaken. But so therefore they didn't know that they were selling marijuana because they thought they were selling hemp. So I think that's pretty much covered everything. Sales, cultivation. An example in cultivation would be that the individual. Let's see, that's a little tougher. I'm trying to think of how I would use a mens
I didn't
rea.
know that marijuana was growing in my front yard.
That would certainly be, there's a plant.
Someone threw a seed out
let's
there.
say there's an old man, he's living in a house, and there's a marijuana plant growing in his front yard, and the cops show up, and they say, you're busted, you're growing marijuana. And he's like,
I just thought it was
I'm
weed.
legally blind, I don't know what you're talking
Oh.
about. I told them to pull all the weeds out there. Those kids must have forgot to pull that one. He doesn't know there's a marijuana plant there. I can see there's a plant there, but he's never seen a marijuana plant. He thought it was a hibiscus. So that's also a mens rea defense to that charge. Now, in possession of marijuana for sale, it gets there's a twist. Because not only does a person have to knowingly possess the marijuana that he's intending to sell, that they're alleging he's intending to sell, knows it's marijuana, but they must prove that he intends, that he has the purpose, the objective to sell it. So if someone gets busted and they've got, say, a pound of marijuana and they go, oh, that's a lot of marijuana, and they're going to charge him with intent to sell, his defense is, are you kidding? I went to California because these prices here in Arizona are ridiculous at the dispensary. I was able to go out there and buy a pound for I would have had to pay like 5 times that to buy a pound here in Arizona. So I just did it, and I'm going to, I have it in the freezer. I'm going to use it over time. So his intent wasn't to sell it, even though it was a whole pound. His intent was to use it himself. So they can't prove intent in that case. He goes, yeah, I know it was marijuana. I know I'm busted for illegal possession, but I didn't intend to sell it. They're not able to prove that intent. And so, without having something more than just weight, unless it's 500 pounds, it starts to get a little hard to, convince a jury that it was just for personal use. But as long as you're in a kind of a gray area, if you will, it could be either way, and it's up to the state to prove to the jury beyond a reasonable doubt that intent existed.
Damn.
So
that's intense.
Yeah. Now it's always a defense though raised at the jury. Someone asked me, "Can I, just plead no mens rea?" Well, no, that's not That's not a plea. You can't just say, when the judge asks you, you're charged with possession of marijuana, do you plead guilty or not guilty? You can't say no mens rea. That doesn't make any sense. If you do that and continue to insist on doing that, the judge is just going to shake his head and write down not guilty, and say, okay, not guilty. I'll set your next court date. If you file a motion to dismiss and say, I'm filing a motion to dismiss for no mens rea, the judge will say, okay, well, unfortunately, that doesn't make any sense. If you want to argue mens rea, I understand what that means. That you have to argue at trial to a jury. So do you want me to go ahead and set this for trial then? And so he'll deny the motion to dismiss and set it for trial is what will happen. So the only time mens rea is a defense is at trial.
Well, they call you Dismissal Dean. Is this true or false?
Speaking of dismissed, there are ways to get your case dismissed, though, and yes, that's very true, and that's been for over 20 years running now.
Well, we want to go over how to actually get your cannabis charges dismissed, but first we're going to take a quick break, so stay tuned.
Hi, I'm Tom Dean, attorney for cannabis. You may know me from my work here in Arizona in important cannabis-related matters like the ASU campus ban case or the cannabis concentrates case, State v. Jones. I've been representing cannabis consumers for 26 years now, and for the last several years, I've been doing nothing but that, representing people in important criminal and DUI cases related to the use of marijuana. If you've got a case involving criminal charges, or if you're just looking for advice or wanting to enter the Arizona's cannabis industry, please give me a call. You can reach me at 602-635-4990, 602-635-4990, or visit me on the web at attorneyforcannabis.com.
This edition of Safer Arizona Wire is sponsored by azmarijuana.com, Arizona's #1 marijuana industry website. azmarijuana.com is your top quality source of Arizona cannabis news and so much more. Bypass the online censors. Sign up for their email list so their content gets sent directly to your email. Bypass the social media shadow bans. Google search AZ Marijuana Facebook, like and follow their page so their content gets sent directly to your feed. Now, back to today's regularly scheduled broadcast. And we're back. I'm here with the man they call Dismissal Dean. Now, I was arrested for marijuana. I was actually facing 3 felonies. I was looking at graduating high school as a multiple felon for marijuana possession and drug paraphernalia. That wasn't very cool. I ended up getting my charges dismissed, but I had to go through TASK, which is a drug diversion program. It took me 6 months. I had to get drug tested every week for 6 months. Now, I actually had a method. I beat TASK. I smoked the entire time on TASK, and I passed every test with my own urine.
Yes, that you can do that.
Yeah.
That is possible.
But anyways, besides that, I had to do a lot of bull crap to get this taken off my record, to get this dismissed. So what are the more practical ways to get your charges dismissed so you don't have to risk getting in a lot of trouble through drug diversion programs and stuff like that?
Right. And sometimes a drug diversion program might be in the best option. So if you get busted, just flat busted, you don't have a medical marijuana card, and they got you, possession of marijuana, and you don't have any good defenses, they're going to be able to prove their case easily against you at trial. Then your best option may well be to do a diversion program, because then, you got to jump through some hoops, but at least you get your case dismissed. Some people say, I'm not going to jump through any hoops. I'd rather just take a misdemeanor.
I don't recommend smoking weed on drug diversion. I know I did, but you can get in trouble doing that.
I wouldn't recommend it. There are ways that there are methods that people use to avoid a positive test, but we're not recommending any of that here today. The traditional way to get a case dismissed, really, and you can challenge the grand jury proceedings. That's a possibility. The problem with challenging grand jury proceedings is you get the case, it simply gets remanded for a new grand jury proceeding, and then whatever they did wrong, they fix, and usually it means they re-indict the person, by correcting their error, having to do it all over again. And now you'd have a really pissed off prosecutor that you're trying to negotiate with, possibly. So that's one way to get a case dismissed, not always the best option. Traditionally, I've had great success in getting cases dismissed by pointing out to the judge, the trial court judge, that the evidence was gathered in violation of my client's constitutional rights, usually Fourth Amendment, Fifth Amendment, or Sixth Amendment rights. Because if the evidence is gathered in violation of those rights, then the state cannot use that evidence against you at trial. Having been deprived of their evidence, their only choice then is to dismiss the case. And it's actually through these types of motions that a judge in Coconino County, this was when I was practicing back in the 90s up in Flagstaff, Judge Flournoy started calling me Dismissal Dean because I was winning a lot of these usually Fourth Amendment related motions to suppress, and some other types of motions to dismiss too. But in any event, the Fourth Amendment by far is the amendment violation. It gives you the greatest leverage in getting your case dismissed.
So how would that be applied to, let's say, marijuana?
Well, so if the Fourth Amendment protects you from unlawful stops, detentions, searches, and arrests. If the police violate those rights, whatever evidence they obtained as a result of that violation cannot be used against you. So let's say they pull you over for, like oftentimes Border Patrol will just willy-nilly pull people over for no traffic violation. That's a violation of your Fourth Amendment rights. They have to witness a traffic violation or have reasonable suspicion that you're involved in criminal activity in order to pull you over. If they lack that, then the stop violates your Fourth Amendment rights, and all the evidence that's obtained after that illegal stop has to be suppressed from evidence at trial. That's called the exclusionary rule. The Supreme Court of the United States developed the exclusionary rule as the most or only effective way of deterring police misconduct. Because it's not realistic that we would expect citizens to sue police departments in order to vindicate their constitutional rights. So what the Supreme Court did is came up with the exclusionary rule so that there is a penalty to law enforcement. If they violated your rights, they lost the evidence, then the case had to be dismissed. And it doesn't always have to be dismissed. Like, let's say they got most of the evidence, but then it was somehow an invalid arrest or an invalid search, and they can be deprived of some, but not all of the evidence, and then that may not...
How do you get an invalid arrest?
Well, they have to have probable cause to arrest you, and if they lack that probable cause, then the arrest is invalid. So, for example, let's say in a marijuana DUI case, they pull you over and they saw maybe a little bit of weaving. They pull you over. Maybe you crossed over the line for a couple seconds. They pull you over for unsafe lane usage. They say they smell marijuana, but you're able to provide them with a medical marijuana card. They ask you to do field sobriety tests, and you decline. Now, what do they have against you? That you made one little drift over the line. No big deal there. Happens all the time. In fact, there's a case in Arizona called State v. Livingston that says that's no big deal. And it's not a proper basis for a stop. And so let's say then that they smell marijuana. You're a medical marijuana patient, no big deal. If that's all they got, you decline to take the field sobriety test, how are they going to, how is that probable cause to believe that you are impaired? It's not enough. So that would be an illegal arrest. They take you down there then and make you do a blood test, because once you're arrested, they'll make you do a blood. You'll agree to it, or they'll get a warrant forcing you to do it. It's an invalid arrest, so they can't use the blood test result against you. They still have this other stuff, weaving, smell of marijuana. Maybe they found some marijuana in the car. They could still attempt to prove that you were driving while impaired. But without that blood test showing that you have THC in your system, their chances of succeeding are dramatically reduced. So sometimes you can deprive some, but not all of their evidence. And of course, searches, they've got to have probable cause to search. Let's say they pull you over, and like I mentioned, they say they smelled marijuana. Well, If you provide them with a medical marijuana card, they're not going to be able to search your car unless they have additional evidence indicating that you're in possession of more than you're allowed to have, or that you're engaged in illegal sales, or some other kind of violation of the Medical Marijuana Act. If all they have is, we smell marijuana in the car, and you provide them with your medical marijuana card, they lack probable cause to search. If they go ahead and do it, you're going to be able to get that marijuana thrown out in most cases. That's based on a case called State v. Cisco and State v. Cheatham from back, I believe, in 2016. So that's an example of an invalid search. And an invalid detention would be, let's say there was a valid stop, and the officer decides, I'm on the DUI task force. I pulled this guy over because he was going a couple miles over the speed limit. I pull him over. I don't smell marijuana. I don't smell alcohol. But I just decide to say, yeah, you mind if I go ahead and I'm going to have you step back out of the car, and you might have consent to search, and you say, no, I don't want you to search. He's like, well, I'll tell you what, I'm just going to have this canine here I got in my car walk around your car. It's only going to take a couple minutes. You're
It
like,
happened
well,
to me.
I don't want that to happen. I'd like to go on my way. He does it anyhow. That's an illegal detention. He's got no reason to think that you have drugs in the car, but yet detains you in order to investigate his, let's say, hunch that you might have a fishing expedition. That's illegal detention. Everything he discovers, even if that dog alerts and he finds 20 pounds of marijuana, it gets thrown out. Okay, so there's all different levels of Fourth Amendment violations throughout a police encounter. And that's the most common way, or traditional way, that we would get cases dismissed. Fifth Amendment violations are where they maybe don't read you your Miranda warnings and start asking you questions after you're arrested. They can't use those statements against you. Sixth Amendment might be where they say, will you submit to this blood test? Let's say you're arrested, and you say, well, I'd like to talk to my lawyer before I make my decision. They say, no, you don't get to talk to your lawyer. You got to decide right now. That's a violation of your Sixth Amendment right to counsel. That also can cause that evidence to be thrown out. Fourth Amendment, that's the big one, but Fifth and Sixth Amendment, you can get rid of evidence enough to get the case dismissed as well when those rights are violated. Now, under the Medical Marijuana Act, though, more recently, since 2010, we have a whole slew of other new ways to get marijuana cases dismissed, and that's based on the Medical Marijuana Act. So instead of filing a motion to suppress for a violation of your rights, you're actually filing, because in the motion to suppress, you get the evidence thrown out, and the state has to dismiss their case. They got nothing left. In medical marijuana, you actually file the motion to dismiss. You say, my rights have been violated because I'm a patient. I'm allowed to possess this marijuana. So let's say that you are pulled over, found to be in possession of an ounce of marijuana. You're like, I'm a medical marijuana patient. And you're like, oh, really? Where's your card? And you're like, oh, no, I left it in my other jacket at home. I don't have it with me. The cop's like, well, tough luck. He cites you. You go to court. And in the meantime, you get your card. Or if you lost it, we get a certified record of your Department of Health Services medical marijuana registration history. And we bring that in so we can prove you did have patient status at the time that the marijuana was discovered, and then file a motion to dismiss, prove that, and the judge orders it dismissed. In that case, usually you just tell the prosecutor ahead of time, look, and he goes, okay, and we'll just dismiss it on his own. But if he doesn't, and I had the first case in Arizona to get a case dismissed under the Medical Marijuana Act, and they didn't want to dismiss it, I had to file the motion to dismiss. And then finally, we got it dismissed. That was actually out of Mojave County. So we're way past that now. Most prosecutors understand that we do have a medical marijuana law in Arizona, and they have to abide by it. Another example would be that you're get busted for cultivation, but you're able to prove that you were authorized to cultivate. So they get a search warrant for a grow. They come in, they tear down your grow. You're charged with serious production of marijuana charges. You're able to go in there, file a motion to dismiss. I filed a motion to dismiss once because they alleged my client was in possession of 15 plants. This was in Navajo County, and was therefore over his allowable number of 12 plants, and thus subject to being prosecuted for felony production of marijuana. He said to me, he goes, I swear, he was in jail, and he said, I only had 12 plants. I don't know what they're talking about. I think maybe they split a couple in half or something. I'm like, well, okay. He said, look, I'm positive. I'm telling you, I didn't have 15 plants. So I said, all right, I filed a motion to dismiss, and I requested that the state produced the plants that they claimed were over the allowable number. They said there were 15. Well, we were there for the hearing on the motion to dismiss, and the state came in and said, well, Judge, I went down and I had them go to pull the plants from the DPS evidence locker, and I asked them, I go, by the way, when you're back down there getting them, give me a call back, let me know how many plants are back there. And they said there's 12 plants. It was just a lie. There was never 15 plants. He said there was 12 plants. Case dismissed. So another case, like I can give you a different illustration, was when someone was charged with possession with intent to sell because they found 3 pounds of marijuana at their residence. It was anything over 2 pounds is mandatory prison if you're convicted. So they're facing mandatory prison, but they were medical marijuana patients, husband and wife, and they said the marijuana, the 3 pounds of marijuana was all powdered up because what it actually was trim, leaf material that they were putting in capsules, and they would take that for their blood pressure. They felt that it helped with blood pressure. So I said, go out with this marijuana and make some more of this powder, and take it to AZ Med Testing, which was the only testing company in the valley at the time, and bring some of the flour and bring some of the powdered leaf material and have them tested. And sure enough, the flour was like 15% and the leaf material was less than 2% THC. And so I went to the prosecutor and said, look, here's the results of this test. The test results in the powder that you have is going to be consistent not with flour, but with leaf material, which is not subject to the weight limitation under the Medical Marijuana Act. So I said, you need to get this tested. They refused to get it tested because the DEA won't test for percentages, and they wouldn't release it to me because they said I'm not authorized to receive the marijuana. They're not allowed to give it to me because it would violate the Federal Controlled Substances Act. And I said, okay, well, then I'm going to go ahead and file a motion to dismiss, and if necessary, go to trial, and you can explain to the jury, why it is that my client is saying, I have a test result of powdered leaf material, that's what this is, but they refuse to do the test. You can explain to the jury why you think you can still prove your case beyond a reasonable doubt. We never got to the motion to dismiss. They went ahead and dismissed it because I think, they obviously knew what was going to happen. So there's all kinds of creative ways in the Medical Marijuana Act that you can use a motion to dismiss based on your immunities under the Medical Marijuana Act. And the only time, though, that you can do that is when you're capable of admitting all of the allegations that they're making. So there can't be any question of fact. So you have to, in other words, they're charging you with knowingly possessing marijuana. You have to be able to go in there and say, I admit I knowingly possess marijuana, and then show your medical marijuana card, case dismissed. If there's any question about fact, then that has to go to the jury. That can't be decided in a motion to dismiss. So if you're saying, let's say that you're caught at your house with 12 plants. You file a motion to dismiss and show you're authorized to cultivate 12 plants. Case dismissed. If there's 24 plants, though, there, and you're saying, well, 12 of them were mine, 12 of them were my wife's. Look, here's my card. The state's saying all 24 were yours. Now we have a factual dispute. That has to go to the jury. That's going to trial. So if it's a question of fact involved, if you're not able to agree with the state on the facts, you're not going to get you're not going to get the case dismissed. You're going to have to go to trial. And it can get more complicated than that. When we have sales-related cases, are always going to be questions for the jury. Because in a sales, you're never, as a cardholder, unless you're a dispensary, if you're a caregiver or a patient, never going to be able to sell marijuana to people. So your only defense there is that you didn't sell, or that you didn't intend to sell the marijuana they caught you with. That's a factual question for the jury. Or let's say you're a caregiver and you're like, hey, I was only receiving reimbursement from my patients. I'm a caregiver. I'm allowed to receive reimbursement. That could be a motion to dismiss, but only if the state agrees that the amount of money they were paying was consistent with reimbursement. If there's a factual dispute there and they say, Well, okay, we agree. You're allowed to be reimbursed by your patients, the ones that the department designated you to. But we feel what you got paid was more than reimbursement and that you were actually profiting from this sale. That's a question of fact. That has to go to the jury. So every case is different, but there's a lot of new ways to get your case thrown out under the Medical Marijuana Act.
Well, Tom, I appreciate that. We're going to wrap this up. Is there anything else you'd like to say before we conclude this broadcast day?
I just think, again, to sum up the mens rea thing, because I know that was what was most important that you were interested in talking about today. Just remember, guilty mind only means that you have one of the mental states that's required for that particular crime, which is going to be either you acted recklessly or knowingly or intentionally. It definitely doesn't have anything to do with your opinion about the law or whether you feel that you acted in any way immorally or that you feel guilty to yourself. That has nothing to do with having a guilty mind. It just means that you qualify for the level of guilt that the state has assigned to that particular crime.
Well, all right. And we just restarted our YouTube. So YouTube search Safer Arizona Wire. It's the one that says Safer Arizona Official. Click subscribe and don't forget to click that little bell to get the notifications so you can get the latest and greatest from the trenches of the drug war with Tom Dean,
All right.
attorney for cannabis. Bye. This edition of Safer Arizona Wire is sponsored by azmarijuana.com, Arizona's #1 marijuana industry website. azmarijuana.com is your top quality source of Arizona cannabis news and so much more. Bypass the online censors. Sign up for their email list so their content gets sent directly to your email. Bypass the social media shadow bans. Google search AZ Marijuana Facebook, like and follow their page so their content gets sent directly to your feed. Now, back to today's regularly scheduled broadcast.
Hi, I'm Tom Dean, attorney for cannabis. You may know me for my work here in Arizona in important cannabis-related matters like the ASU campus ban case or the cannabis concentrates case, State v. Jones. I've been representing cannabis consumers for 26 years now, and for the last several years, I've been doing nothing but that, representing people in important criminal and DUI cases related to the use of marijuana. If you've got a case involving criminal charges, or if you're just looking for advice or wanting to enter the Arizona's cannabis industry, please give me a call. You can reach me at 602-635-4990, 602-635-4990, or visit me on the web at attorneyforcannabis.com.